Landlord must allow an assistance dog as a reasonable accommodation for a handicapped tenant. Facts: a landlord wishes to rent his unit to a handicapped tenant who uses an assistance dog. Issue: may the landlord charge a pet deposit for the assistance dog? Answer: no. Charging a pet deposit would likely be an act of discrimination under the Fair Housing Act. Discrimination under the Act includes a refusal to make reasonable accommodations in rules, policies, practices, or services when such accommodations may be necessary to afford a person with a disability equal opportunity to use and enjoy a dwelling. 42 U.S.C. Paragraph 3604 F. 3b. So long as the requested accommodation does not constitute an undue financial or administrative burden for the landlord or fundamentally alter the nature of the housing, the landlord must provide the accommodation. Arizona Realtor R. Magazine, February 2012. Professional office building owner and tenant are obligated to make public restrooms wheelchair accessible. Facts: the commercial office building was constructed in 1960. The building has multiple offices and rents office space to various types of business. The owner-landlord recently rented office space to a tenant who operates a professional services business, tenant, and who happens to have a disabled employee that requires the use of a wheelchair, employee. The door to the office bathroom is only 24 inches wide. In this regard, the employee's wheelchair will not fit through the bathroom door, and the employee cannot access the bathroom. Issue: must the landlord and/or tenant alter the bathroom so that it is accessible to a disabled person in a wheelchair? Answer: yes. Title III of the Americans with Disabilities Act, ADA, covers, in pertinent part, places of public accommodation and commercial facilities and extends to private entities. See 28 CFR paragraph 36.1011 et al. Pertinent here, places of public accommodation are facilities whose operations affect commerce and include various categories enumerated under the ADA. Of these categories, service establishments such as offices of accountants and lawyers, insurance offices, and professional offices of healthcare providers are included. According to the ADA, both the landlord and the tenant have full responsibility for complying with all of the Title III requirements applicable to that place of public accommodation, i.e., the tenant's office. The Title III regulation permits the landlord and the tenant to allocate responsibility in the lease for complying with particular provisions of the regulation. However, any allocation made in a lease or other contract is only effective as between the parties, and both the landlord and the tenant remain fully liable for compliance with all provisions of the ADA relating to that place of public accommodation. Title III of the ADA prohibits discrimination against any individual with a disability. Accordingly, individuals with disabilities may not be denied full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations offered by a place of public accommodation. Sue Note Color FFF66 Text Color C09853 Radius 3 Class Alert Notice. Under Title III, architectural barriers must be removed when it is readily achievable to do so. According to the ADA, architectural barriers are physical elements of a facility that impede access by people with disabilities. Determining if barrier removal is readily achievable is necessarily a case-by-case judgment under Title III. However, the ADA presumes that widening doors is readily achievable. That being said, in this case, it would likely be found that widening the bathroom door to accommodate the employee's wheelchair would be readily achievable. Therefore, the landlord and the tenant are responsible for accommodating the employee by widening the bathroom door for wheelchair accessibility. See note. Note: this does not address Title I of the ADA dealing with an employer's obligations to a disabled employee with respect to making accommodations, as this would be outside the scope of the AAR legal hotline. Arizona Realtor, Magazine Property Management Company, cannot require compliance with swimming pool barrier laws. Issue: the property management company has a swimming pool barrier policy for tenants with children. This policy requires tenants with children to install a fence or otherwise comply with swimming pool barrier laws. Furthermore, at the termination of the tenancy, the tenant is required to remove the fence or other improvements at the tenant's expense. Is this policy in compliance with fair housing laws? Answer: probably not. Familial status, such as tenants with children, is a protected class under fair housing laws. If the property management company has a policy which places conditions or restrictions upon the rental because of familial status, e.g., compliance with swimming pool barrier laws, the property management company has probably committed a discriminatory act under the fair housing laws. CARS, Paragraph 41, 1491.01. Real estate licensee must comply with Fair Housing Act, even with personal residence. Facts: a real estate licensee owns a single-family residence. The garage of the home has been converted into a small studio apartment. The licensee wants to advertise the studio apartment for rent to a single person. The licensee believes she can advertise for single tenants because she is exempt from the fair housing rules as her property is an owner-occupied property. Issue: can a licensee advertise her studio apartment for rent to a single tenant only? Answer: no. An agent homeowner cannot publish a discriminatory ad or advertise in violation of the Fair Housing Act. There are, however, limited circumstances where a guest house of an owner-occupied property can be restricted to single persons or a specific gender. Regardless, these limited exceptions to the Fair Housing Act do not apply when a real estate licensee is involved in the transaction. See 42 U.S.C. Paragraph 3603.